This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Yesterday, the internet blew up with reports like this one from Mike Cernovich. Patreon loses lawsuit against Owen Benjamin fans. As reported on cernovich.com, today a trial court denied Patreon's motion for a preliminary injunction. Patreon lost their lawsuit in court and must not proceed to arbitration. I'm pretty sure that he means Patreon must now proceed to arbitration. The report goes on to summarize that Patreon originally banned a comedian by the name of Owen Benjamin. Benjamin's backers moved for arbitration, alleging various causes of action. Under Patreon's dispute resolution clause in its terms of service, Patreon must pay the filing fees, which could total millions of dollars, says the article. Patreon cannot collect those fees back even if Patreon wins the arbitrations. If true, this could be the start of a very difficult time for Patreon. A well-known effect of frivolous lawsuits is the potential to exhaust one party's resources before they can win their case. This is often a tactic of copyright and patent trolls, many of whom use litigation as leverage against defendants who lack the resources to properly defend themselves. Well, lawful masses, I'm sure you know that legal commentators often get it wrong, so why don't we take a look for ourselves and see what is really going on here? We'll take a look at Patreon's terms of service, the arbitration clause, the arbitrator's costs and terms, and see if we can evaluate the likelihood that Patreon is really facing millions of dollars in arbitration costs. But first, let's quickly review a case we've already covered on this channel where something very similar happened to DoorDash. Back in February of 2020, we reported on a lawsuit brought by DoorDash workers who disputed their classification as contractors versus employees. DoorDash's terms of service had a dispute resolution clause requiring arbitration before the American Arbitration Association. Approximately 5,000 workers filed arbitration actions requiring DoorDash to pay nearly $12 million in arbitration fees just to get started. DoorDash unsuccessfully argued that it was settling the case which began the flood of arbitrations and therefore it could have a stay or hold on any further arbitrations until that settlement and its terms were final. But the court said that DoorDash made its own bed, and now it has to lay in it, saying, quote, "For decades, the employer side bar and their employer clients have forced arbitration clauses upon workers, thus taking away their right to go to court, and forced class action waivers upon them too, thus taking away their ability to join collectively to vindicate common rights. The irony in this case is that the workers wish to enforce the very provisions forced on them by seeking, even if by the thousands, individual arbitrations, the remnant of procedural rights left to them. No doubt, DoorDash never expected that so many would actually seek arbitration. Instead, in irony upon irony, DoorDash now wishes to resort to a class-wide lawsuit, the very device it denied to the workers to avoid its duty to arbitrate. This hypocrisy will not be blessed, at least by this order. Damn, brutal judge is brutal. But will the same thing happen to Patreon? Let's dive in. Supposedly, this whole thing got started when Patreon banned a creator by the name of Owen Benjamin. Wikipedia says that Owen Benjamin Smith is an American comedian, actor, and alt-right political commentator. Quote, in October 2009, Patreon suspended Benjamin's account, saying he violated their terms of service regarding hate speech. On January 6, 2020, Benjamin and 100 fans, as leverage to attempt to convince Patreon to settle, announced that they would be suing Patreon for $3.5 million for banning him from the platform. Patreon would later file a countersuit against 72 of the fans. But Patreon's previous terms of service required claims to be submitted to arbitration, which would include Benjamin's $3.5 million claim. Patreon updated its terms of service effective January 1st, prohibiting users from filing claims based on the platform kicking someone off. Patreon also updated the terms to require anyone who files such a claim to pay the company's attorney's fees and costs. Patreon's terms of use are listed on their website. The current version, as of the making of this video, has several relevant clauses. There is an indemnity clause that claims that patrons indemnify Patreon from all losses and liabilities, including legal fees that arise from these terms or relate to your use of Patreon. There is also a warranty disclaimer clause saying that Patreon is provided as is and without any warranty of any kind. There is a limitation of liability clause that limits your recovery to the amount of money Patreon earned from your use of Patreon, which sounds an awful lot like actual damages minus Patreon's expenses. The most relevant clauses seem to be the dispute resolution clause. It says, if a dispute arises out of these terms or related to your use of Patreon and it cannot be resolved after you talk to us, then it must be resolved by arbitration. This arbitration must be administered by JAMS under the streamlined arbitration rules and procedures, except as expressly provided below. Arbitrations may only take place on an individual basis, no class arbitrations or other grouping of parties is allowed, and you waive your right to trial by jury or to participate in a class action or representative proceeding. Patreon also waives these rights. And then there's this critically important section, quote, for creators and patrons who are consumers, we also follow the JAMS policy on consumer arbitrations pursuant to the pre-dispute clause's minimum standards of professional fairness for consumer arbitrations done under these terms. And then here's the section that Patreon is accused of inserting in response to the initial Owen-Benjamin dispute. Quote, this clause does not limit either party's ability to file an action in court with jurisdiction to seek injunctive or other equitable relief for disputes relating to intellectual property, proprietary data, or to enforce this dispute resolution clause, including your agreement not to assert claims related to the suspension or termination of another person's account. In any such action, the court, rather than an arbitrator, must decide whether such a claim is arbitrable and must decide whether the party is entitled to the requested injunctive or other equitable relief. For our purposes, we can assume that injunctive or equitable relief is the same thing. They are seeking a court order stopping the Owen-Benjamin patron arbitrations. Meanwhile, the JAMS consumer arbitration minimum standards require, among other things, that, with respect to the cost of the arbitration, quote, when a consumer initiates arbitration against the company, the only fee required to be paid by the consumer is $250, which is approximately equivalent to current court filing fees. All other costs must be borne by the company, including any remaining JAMS case management fees and all professional fees for the arbitrator's services. When the company is the claiming party initiating an arbitration against the consumer, the company will be required to pay all costs associated with the arbitration. So this means that the party initiating the arbitration, which here is Owen-Benjamin's former patrons, only have to pay $250 to initiate the arbitration, and that's it. Even if they lose, because the case is in California, they may not have to pay the costs. The clause does say may and not shall, which could be an operative distinction. So now that you understand the law behind what's going on here, let's turn to the judge's ruling against Patreon and in favor of Owen-Benjamin's former patrons. All right, so here is the lawsuit. Now this is filed in the Superior Court of the state of California. This would be, I believe, the lowest court in the county court of California, basically. And this is filed July 29th. This is the judge's order, so it's not some party's memo or motion. This is the judge's order on Patreon's motion for a preliminary injunction. And so the judge writes, Patreon seeks a preliminary injunction to enforce defendants from continuing to pursue improper claims against Patreon in JAMS arbitration, pending this court's consideration and final adjudication of Patreon's complaint for a declaratory judgment. Defendants are individual claimants in 72 pending JAMS arbitration proceedings against Patreon. Patreon claims that those claims are barred by its terms of use because they involve non-arbitrable claims. Patreon's request for a preliminary injunction is denied for several reasons. First, Patreon fails to show that it will suffer an irreparable injury or interim harm if the injunction does not issue. This is the basic requirement for a injunction. So if you're a law student studying for law school and you're starting to figure out, what do I need to say on the bar exam when they start talking about injunctions, the number one thing you want to remember is you need an irreparable injury. Your injury cannot be redressed with money damages. Here, Patreon's injury probably could be redressed by money damages, making it not an irreparable injury. The judge says, JAMS has agreed to determine the threshold jurisdictional issues Patreon raises and will afford Patreon an opportunity to object to its jurisdiction in the course of the arbitration proceedings. If Patreon is correct that defendants' claims are not arbitrable or are outside the scope of the parties' agreements, the arbitrators presumably will rule in its favor on those issues. Merely having to incur expense in order to participate in arbitration proceedings is not irreparable harm. So, yeah, that's a pretty big one. Patreon has to pay for what it wanted. It wanted arbitrations instead of court proceedings, so therefore it has to pay for them. What did Patreon think was going to happen? They thought that arbitration would somehow be cheaper than court, which isn't always true. If these 72 proceedings were initiated in court, the consumers or patrons would have to file lawsuits individually at $400 a pop, and Patreon would be able to respond to them only for the cost of their attorneys. Now it's the cost of their attorneys plus the entire cost of the arbitration proceeding. And we'll get to the costs of that in a moment. Second, Patreon fails to show a reasonable likelihood of prevailing on its claims. This is the second factor of a request for an injunction. You must show a reasonable likelihood of prevailing. Even if Patreon were correct that defendants' claims are not arbitrable, those issues are for the arbitrator, not the court, to decide. Quote, an arbitration provisions reference to or incorporation of arbitration rules that give the arbitrator the power or responsibility to decide issues of arbitrability may constitute clear and unmistakable evidence that the parties intended the arbitrator to decide those issues. That's a complex sentence. What's going on there? So there's an arbitration provision in a contract. So contract law applies. If the arbitration provision refers to the rules, says we're gonna arbitrate according to the JAMS streamlined rules or the JAMS consumer rules or something like that. Well, those are the rules we looked at before. If those rules say that the arbitrator does resolve disputes over arbitrability or arbitrateability, then that will be used as evidence to show that that's what the party's contract meant. So here, that means even though Patreon put an exception into their contract, they previously said the JAMS rules applies, in so many words. And so here the judge is going to say the JAMS rules apply, and the arbitrator can decide what is arbitratable. Rule 8b of the JAMS Streamlined Arbitration Rules provides jurisdictional and arbitrability disputes, including disputes over the formation, existence, validity, interpretation, or scope of the agreement under which arbitration is sought, and who are proper parties to the arbitration, shall be submitted and ruled on by the arbitrator. The arbitrator has the authority to determine jurisdiction and arbitrability issues as a preliminary matter. Indeed, Patreon asserts that a JAMS arbitrator has already ruled in its favor in a similar case. That also kind of puts a bookend on Patreon's costs. The arbitrator probably isn't going to have $10,000 worth of arbitration costs to resolve arbitrability issues as a preliminary matter. But yeah, there's going to be probably a couple $1,000 down payment that Patreon has to make in each case just to get started. Third, California courts rarely grant the extraordinary relief Patreon seeks here, an injunction interfering with an ongoing contractual arbitration proceeding. Once a dispute is submitted to arbitration, the California Arbitration Act contemplates limited, if any, judicial involvement. Typically, those who enter into arbitration agreements expect that their dispute will be resolved without necessity for any contact with the courts. It is the job of the arbitrator, not the court, to resolve all questions needed to determine the controversy. That conclusion is especially true where, as here, the arbitration began without the need to seek a court order compelling arbitration. As another court has explained, an arbitration has a life of its own outside the judicial system. The trial court may not step into a case submitted to arbitration and tell the arbitrator what to do and when to do it. To be sure, Patreon is correct that this principle is not an inflexible one. However, the cases Patreon cited for the first time at the hearing do not support its position, either because no issue was actually raised or decided on appeal as to the propriety of such injunctive relief, or because they are readily distinguishable on their facts. So the first one is an issue where the employer conceded the issue is not arbitrable already. The second one is a case where the trial court denied repeated requests to stay the proceedings, but suggested that if an arbitrator or sponsoring organization mistakenly accepted jurisdiction, a party may seek judicial relief to enjoin the arbitration. Another case, the American Arbitration Association advised the parties that it would resume an arbitration unless there was a court order staying the arbitration, so that was why somebody could intervene in court. The Briggs case is closely analogous, the court says, and that was the one from above, the first one we looked at. There, the arbitrator stayed an uninsured motorist arbitration pending a determination of the insured's entitlement to workers' compensation benefits. The insured sought a petition for writ of mandate, which the trial court denied on its merits. The Court of Appeals affirmed on other grounds, holding that the trial court lacked the authority to review a discretionary pre-hearing order of an arbitrator. As it explained, the trial court conducted what amounted to a de novo review of an arbitrator's interlocutory order, or in the middle of litigation order, something it had no statutory authority to do for any reason, so the court can't step in. Here, Patreon is effectively seeking similar relief. Immediate review of JAM's interlocutory orders, submitting the contested issues to the arbitrators for decision, rather than immediately granting Patreon's objections to arbitration or its alternative request to issue a blanket stay of the arbitration proceedings pending a ruling on Patreon's request for coordination of those arbitrations. Under Briggs, the court lacks any authority to review those administrative decisions. Accordingly, the court denies Patreon's request for a preliminary injunction. It is so ordered, the Honorable Ethan P. Schulman, San Francisco Superior Court, which is the right, it's the correct outcome. Like the DoorDash case, they made their bed and they must now lay in it. They wanted to deny class actions. They wanted to deny court review. They wanted to deny jury trials. And now they have 72 pending arbitrations against them. It will probably not be millions of dollars in arbitration fees, but there's a couple steps here where Patreon will have to pay at each step along the way. They'll be required to make an initial payment to JAMS in order to initiate the arbitration from Patreon's side. So yes, the Owen Benjamin patrons initiated the arbitration, but once their side is taken care of, Patreon will be required to make the payment of whatever is due to get started. Then, once the parties obtain an arbitrator, they will have, each arbitrator has a list of fees, and there have to be a basic deposit on those fees. By the time you get done with this, you're already at $5,000 or $10,000. So yes, if the arbitrator lets these cases go beyond a preliminary matter or an initial dismissal kind of thing, I expect that there will probably be several $1,000s in fees for each one of these things. Could Patreon then recover for frivolous lawsuits? They're going to try. I don't see why they wouldn't try. Yes, there's a provision in there that says that under California law, you can't recover when the consumer loses, but I'm not sure if there's an exception in there for bad faith lawsuits or frivolous lawsuits. I'm not sure that the Owen Benjamin fans have a great case or a bad case. I haven't seen the individual claims, but my initial reaction is that they can't recover from Patreon just because Patreon banned Owen Benjamin. I don't think that's the way it works, with or without the language changes in the terms of service that Patreon did on January 1st. I don't think they're the Owen Benjamin fans are going to be able to recover anything. The question then becomes, can Patreon go back the other direction? Say, these were filed frivolously. These people knew that they weren't going to win, but they filed anyway. There might be something to recover from. And the language in the terms of service says that there may be a recovery possibility, not shall be denied recovery. So that's probably going to hurt Patreon a little bit. I'm not exactly sure what their annual revenue is or how much money they have in the bank. Maybe they can afford $1 million. They're a couple years old. They have a lot of very, very large patrons on their platform. We actually have an alternative platform. Sponsus.org is a platform that was created by one of our sponsors. One of our supporters created a new platform just for, well, not just for us, but just for the people who were having trouble with Patreon, because we wanted an alternative to Patreon, because they pull stuff like this every once in a while. A couple years ago, it was when they started banning people. A year before that, it was when they switched to a different way of charging your credit card, and you were going to get charged one transaction fee for every patron you support, or every creator you support. And that was ridiculous, because it would end up meaning that if you supported a bunch of creators at $1 a piece, you were really only going to give them like 50 cents because the transaction fees, as opposed to Patreon, charging your card for the entire amount and then distributing it and sort of prorating or distributing the fees across it all too. So that was pretty untenable. So I do think that Patreon will have to arbitrate these 73 cases. How far the 72 potentially frivolous cases get has yet to be seen. The arbitrators are smart. They're usually former judges, and I don't see any reason why they wouldn't properly evaluate whether the claim made by the Owen Benjamin fans can even be adjudicated by a court. In other words, there needs to be a remedy that a court can grant or an arbitrator can grant. What is the remedy? What is the legal claim here? That they kicked Owen Benjamin off the platform. They're allowed to do that. What's the damage? I don't know. I don't see how there's anything but maybe a refund due for any prorated support that, if he was cut off on the 15th of December, maybe they owe you half of your money back for the rest of December or something. I don't see how it's any worse than that. This might make companies pause in creating their arbitration clauses, because now that various courts have all sided with consumers and allowed arbitration clauses but denied the companies shifting the fees onto the consumers, this means that anytime there's a dispute, the consumer gets to have the dispute basically for free or for low cost, and the company who preferred arbitration and preferred no class actions and all that suddenly has the expense of paying for the arbitration, and they have no chance of recovery. I was able to use this to my advantage last year when I had a dispute with Dropbox. They changed their format. The required format of your hard drive used to allow for exFAT, and I use a lot of exFAT drives because videography. You don't use NTFS for videography, you use exFAT for videography. So my Dropbox is on one of my drives that I'm also using for videography, and they're like, no, we need you to move your 3 terabyte Dropbox because we don't want to use exFAT anymore. So I said, okay, I don't want to do that. Please close my account, give me a refund or whatever. They said, no refunds. I said, okay, I'm enacting your arbitration clause here. I sent a letter to them or whatever. I got a reply. We'll give you a full refund. Way easier than going to arbitration, because they were going to have to pay thousands of dollars so that they didn't have to refund me $75. They actually refunded me the entire fee instead of just the $75, which was half. So it worked. I can't say it doesn't work. And I have another one of these. A company, stamps.com or Endicia, Endicia, they keep sending me bills. I've canceled my account. I canceled my account 2 years ago, and they keep sending me bills over every day. I get a bill in my email. You would think I can just train Gmail, when you see a bill, throw it into spam. Well, I don't want to train Gmail. When you see a bill, throw it in spam. I want them to stop. So I've written to them dozens of times to please stop. So next step, I'm going to enact their arbitration clause, and we'll see whether they want to pay an arbitrator in order to not have to stop sending me spam emails. We'll see. So what do you guys think? That's really an interesting set of circumstances. It seems more like the arbitration clause and its effect on Patreon are being used to protest Patreon's banning Owen Benjamin from the platform and not to make an actual legal claim. But I guess we'll see what the arbitrators come back with in their report and recommendations. The arbitrations themselves are private, and if the parties conclude the arbitrations in a way that's confidential, we'll never know anything unless something leaks. But if somebody takes it all the way through to some kind of conclusion and the arbitrator issues a report and recommendation in the case, then that'll probably be on the public docket someplace. Maybe in the Superior Court, maybe in a federal court, or maybe a party will share the documents. Sometimes the parties will get a confidentiality agreement or will make a confidentiality agreement, and then that's the end of any publicity for that case. Thank you very much for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube and Twitch and Floatplane. We're still on the month of July. August 2nd will be when we start thanking the August supporters. Thank you very much to BU1 Simmons in the month of July. Really appreciate your support. Thank you to the following $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ammonite, and Brandon Abel. And thank you to the July $5 plus supporters who are scrolling on the screen in front of me, and you'll all be in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. I love you all. I'll see you in the videos. Bye.